October 2019 term was par for the year. It was big, it was strange, it was unpredictable. We had big cases, everything ranging from immigration to contraception to abortion to much of Oklahoma being declared Native American territory. Booking.com had applied for what's called a service mark. It's basically a trademark for services. And the question in this case is, how do we determine whether something's generic or distinctive, particularly when you're combining two generic terms like booking and .com. Oral argument was spicy. It was the first argument to happen by phone, and it's quite jarring if you listen to it. Typically, we always have advocates getting cut off, but the justices allow the advocates to make a point and then they jump in and the conversation changes. Whereas here, with the phone arguments, the Chief Justice had allotted a certain amount of time to each justice to ask questions, and as soon as that justice's time was up, he swiftly cut off the advocate, and that resulted in a lot of questions just simply going unanswered. Justice Ginsburg wrote the opinion. It was an 8-1 opinion that was relatively short and straightforward, and it just says that as a matter of common sense and consistent with the Patent and Trade Office's own practice and history, there's no per se rule on a generic .com gaining trademark protection. And there's just something inherently different about .coms and the fact that they're domain names that make them distinctive. And it makes more sense to ask what consumers think rather than just banning generic .coms from patent eligibility. The plaintiff in this case was Miss Babb. She was a pharmacist for the VA Medical Center, and she brought a case for age discrimination against the Secretary of the VA, Wilkie. Babb brought her case pursuant to the Age Discrimination in Employment Act, which governs the way that the federal government must treat their employees. And so the question is unique to the text of that act. Justice Alito wrote the majority opinion in this case for 8 members of the court, and he says that age does not need to be a but-for cause. Any consideration of age is enough to subject a federal employer to potential liability. But he does not go as far as Babb would like. He doesn't say that any mention of age throughout the entire process can subject somebody to liability. It has to actually play a part in the ultimate decision. Justice Thomas, for his part, in dissent, says, "You're making all of this up. The text is not different enough in this particular act from previous age discrimination statutes to totally upend the system, to abandon the test that we traditionally use." What's interesting about this case is that both the majority and the dissent claim to be engaging in textualism. So we have 2 of the most committed textualists on the court, Justice Gorsuch and Justice Thomas, coming out on opposite sides. So I think it reflects the idea of something that Justice Kagan said a few terms ago in a speech. She said, "We're all textualists now." It may surprise you to learn that there is a ban on robocalls because we all receive them all the time. They're incessant. One of the reasons is because there's an exception to this outright ban, and that is for anybody who's calling to retrieve debt that is owed to the government or secured by the government. Any law that makes a distinction based on the content of speech is subject to strict scrutiny. The test for whether a law is content-based was recently affirmed in Reed versus Town of Gilbert, a Supreme Court case from a few terms back. And under that case, the court says all you need to look at is whether a person has to think about the content of the speech in order to determine whether a law applies. The plaintiffs in this case were a group of political organizations who argue that there's no good reason for the statute in the first place, that you are violating their right to free speech, that is to call people and speak about political things, for no good reason. The government argues that the court should see the case entirely differently, that it really should see the case as a challenge only to the exception, that the exception is arbitrary and favors government speech over political speech, In an opinion by Justice Kavanaugh, the court rules that the law is clearly a content-based restriction on speech. It restricts some speech and not others based on its content. Under Reed, that's good enough to subject the law to strict scrutiny. And so ultimately that government debt exception has to fall. When you look at the dissent written by Justice Breyer, he just doesn't buy that test. He didn't buy it in Reed, and he doesn't buy it now. He doesn't think that the First Amendment was meant to protect speech that pertains to economic regulations. And so when we're crafting a test for content-based restrictions, we should take into consideration what type of speech it is and how important it is before providing a blanket strict scrutiny test.